Stoker, I think you're going to take us on to the 1954 Act.
Yes.
And in relation to that, we wanted to tell you that, I'm sorry, it's a little bit later than intended. I apologise for having keeping you waiting. We want to tell you that we have looked at those cases, and so we'd be interested to know what proposition you put them forwards for.
I'm very grateful.
And just, little references. Thank you.
I'm very grateful. I'll start, if I may, with the Act itself, which is in tab 2 of the Authorities Bundle. And at page 43, we have section 24, which is the equivalent of paragraph 30. It's to say that's what affects the continuation under the 54 Act. And in answer to a question my Lord Holgate raised yesterday, it's 24.2 that prevents the tenancy coming to an end by notice to quit given by the tenant by surrender, or sorry, the statutory scheme doesn't prevent the coming to an end by notice to quit given by the tenant surrender or forfeiture. So that's the provision which is missing, not copied across in the code. And then turning on to page 46, we have section 25, which is the equivalent, we say, of paragraph 31, provides that the landlord can terminate a tenancy by notice in the prescribed form. And then again at subsection 3, this time they're reversed, so the relevant one is A. It says it can't be, the date can't be given effect, sorry. Subparagraph 2 says it has to be given not more than 12 nor less than 6 months before. So that's the equivalent of our subparagraph A. And then paragraph 3 is the equivalent of our B. And it says that the date is to be not earlier than the earliest date on which, apart from this part of this Act, the tenancy could have been brought to an end by notice to quit, given by the landlord on the date of the giving of the notice under this section. So I invite your ladyship and your lordship to note these things. Firstly, the could have wording appears in section 25 as well. So it's the same inquiry, we say, in the 54 Act, which is whether you could have brought the tenancy to an end by a notice to quit. Notice to quit is defined in the 54 Act as being a notice to quit or a break notice.
That's section 69.
It is. I'm afraid we didn't copy that, my lord, but that is the law. I don't think that's disputed. So this is dealing with the situation where you could have brought your tenancy to an end by your notice to quit or break clause. The provision here is that your statutory notice is to be given not earlier than the earliest date. So there's a difference between the code and the 54 Act, because under the code, your statutory notice has to be given at a time when you could have. And the other difference is that in the 54 Act, the hypothetical contractual notice has to be one that could have been given on the date of the giving of the notice under this section. And that wording isn't copied across. That isn't copied into the code. We say that's deliberate. So the wording, we say, is very similar to the wording that we have in paragraph 31. And as I mentioned already, it's clear from the Law Commission that they intended to use the 54 Act security regime as a model. I don't think it's necessary to turn up the references now, but the relevant passages are on page 287 and then 291 to 294 in the supplemental bundle. And so we say, given that background, and it is generally accepted that the code is modelled on the 54 Act, that Part 5 is modelled on the 54 Act. Given that, your lordships and your ladyship would need to have a reason to construe the code, paragraph 31.
No, sorry, that depends on how similar the codes are in the first place.
Well,
which begs the question, how useful this is. But you don't just read across the interpretation given by a court to a phrase which happens to appear in another statute without asking yourself the prior question, how similar are the statutes?
Well, my lord, with respect, I'd like to attempt to persuade the court they're very similar, because there is a statutory continuation of the agreement in both cases. And then there is a statutory right to terminate on statutory grounds in both cases. In both cases, what's required to trigger the statutory right to terminate is a notice. And in both cases, the notice has to specify a date, and there are some statutory provisions about how that date's to be calculated, and they have to state the statutory grounds. All of that is the same across both regimes. And of course, it's to be remembered that before the code, a lot of these telecoms leases would have been governed by the 54 Act. Some of them were governed by the 54 Act in the old code. That was how it was. And what Parliament said was, we're going to take you out of the 54 Act and we're going to put you into the new code.
Can I ask you something? First of all, by reference to this Act and then by reference to the code. Suppose you have a tenancy which has is fixed term, no break clause, none of that.
Yes.
And the tenant is in repudiatory breach, which would entitle the landlord to accept that as putting an end to the contract. Am I right in thinking that the effect of 25(4) and the other provisions here is that that doesn't have any effect at all? It just it continues because it's got to, under 4, can't specify a date earlier than the date on which, apart from this part of the Act, the tenancy would have come to an end by a fluctuation of time, and the previous provisions are only concerned with notices to quit.
Well, under the 54 Act, of course, in many cases, the landlord would have a right to forfeit, and the right to forfeit is preserved in the 54 Act. So under the 54, in that repudiatory breach situation, in many, many cases, almost invariably, that would trigger a right to forfeit, and the landlord could rely on his right to forfeit, and he doesn't need to be concerned with this statutory termination regime.
Is it typical, for example, for there to be a right to forfeit if the tenant says, I do not intend to abide by my obligations in the future? A renunciatory breach?
I can't say I've seen that.
So suppose that's what happens, just hypothetically. In a 1954 Act case,
then I think
the
landlord waits until there's actually a breach.
You can't.
But once there is a breach, once that comes about, once the tenant stops paying the rent, then the landlord would be able to forfeit, and he wouldn't have to worry about the date on which he could have broken or wait for a fluxion of time. He just relies on his preserved right to forfeit. But that isn't copied across into the code.
No. So far as the code is concerned, it's not framed in terms of notices to quit or anything like that. It's right to terminate, and it's not only concerned with tenancies. It's
concerned with licenses, and that's why it's...
So again, take my example. There is a repudiatory breach, which is not in fact accepted by the site operator. Repudiatory breach by the operator, not in fact accepted by the site operator, but the site operator issues a statutory notice under paragraph 31. That's the hypothesis. I think you say then the effect of subparagraph B, second limb, is could have accepted it, although they didn't, and therefore it's
paragraph 31 is enough.
So it's 18 months, and B is nil. So that in those circumstances, an unaccepted repudiation is written in ink, not in water, to use the famous metaphor.
Well, I suppose the point is that if you have to show that if the statute wasn't there, the statute's not accelerating the time on which you can recover, you can terminate the agreement.
Well, it is, because if you haven't accepted the repudiation and the hypothesis is a 20-year unexpired term without a break clause, it's accelerating it by the unexpired term less 18 months.
But you could have done, and if you assume that you want to terminate, otherwise you wouldn't get into the scenario of serving the paragraph 31 notice in the first place. You've made a decision to terminate.
Yes.
And so if paragraph 30 didn't have the effect it does of saying, well, that would all be futile and pointless, then instead of serving your paragraph 31, what you would have done is just accepted the repudiatory breach. So we're not in a situation where there's any doubt in the site providers.
You still have to do both. It's protected code rights. You still have to give 18 months notice under the statute. And contractually, you'd have to accept the repudiation as putting an end to the contract. But I think your argument is you don't, for the purposes of the code, you don't actually have to accept.
Yes, because the code has given the site provider a statutory right to terminate that type of agreement.
Right.
And so he's relying on his statutory right. He doesn't have to. He's got a choice, except that it's not a choice because he can't actually rely on his common law right to repudiate because paragraph 30 says that. And what he's got instead of that is a statutory right. And if the statutory right didn't say anything about could have or anything else, if it just simply said, whenever you like, you site provider, you can terminate on 12 months notice, then all he'd have to do, he could choose to exercise that statutory right on his 12 months notice. The reason it gets a bit more complicated is because Parliament wanted to give that protection by saying, actually, site providers can't terminate any earlier than they would have done. You still got to look at the underlying contractual regime to find out when they would otherwise have been able to terminate. We're not giving them, we're giving them a freestanding right, but it's against that background. So that date on which they can exercise that freestanding right is, you still refer back to the contract in order to establish that.
But in this situation, a repudiatory breach, which is not accepted,
yes.
So the election isn't made to treat the agreement as at an end. We're postulating that there'll be a paragraph 31 notice.
Well, that's really the point, isn't it? The election is made to treat it at an end, otherwise you wouldn't serve the paragraph 31 notice.
That's really what I was going to lead to.
Your point is that although you would expect someone actually to accept it, they don't accept it by serving the paragraph 31 notice, do they?
And it suffices that they could have done.
Yes. I think we're slightly talking at cross purposes because in reality, the example that your lordships give isn't a situation where it's possible to serve a paragraph 31 notice without making clear that you've decided you want to bring it to an end. It's not the could have situation is very difficult to imagine in that situation because you are deciding by serving your paragraph 31 notice, you are deciding that actually you're taking steps to bring it to an end.
No, sorry. Suppose in the circumstances I've posited, there is a repudiatory breach.
Yes.
By reason of the operator saying, I don't intend to be bound by this particular clause or something.
Yes.
You serve your paragraph 31 notice saying, I wish to redevelop the site. That's my statutory reason.
Yeah.
You don't, on your case, have to identify why you're entitled in an agreement that's still got 20 years to run. Why you're saying you're contractually entitled to bring it to an end, and you can wait and see whether you can prove that at the end of the period. Have I understood the effect of your argument?
Yes, I'm saying you don't have to explain that in order for your paragraph 31 notice to be valid, because there's nothing in paragraph 31 that says you've got to state anything other than your statutory ground.
So when the, I'm sorry to interrupt you. So when the site operative, when the notice is received, and there's no reason given as to why there's an entitlement to give it with only 18 months' notice, you just have to go through the counter notice proposals. You're waiting to see in due course what reason is going to be given.
Well, my lord, we did engage with this a little bit below. The reality of it is that whatever information is given in the statutory notice or indeed a contractual notice, there needs to be a process of discussion between the parties in order for anyone to know whether that notice is really going to be effective or not. So, for example, if one said, we've got a redevelopment break and we rely on the redevelopment grounds, that alone isn't all the information that the recipient needs in order to understand whether that is going to be an effective notice or not, because they need to know more about the scheme. They need to know whether the work is going to be sufficiently.
No, I'm not on that point. But I think you say the tribunal was wrong to say that although you don't have to exercise your contractual right, you do have to identify the right and
Yes.
the reasons why
Yes.
you're entitled to exercise it.
Yes.
And you say the tribunal was wrong about that.
Yes.
If you've got an unexpired term of 20 years and you happen to think you've got a case for repudiatory breach, you don't have to say anything about it. So you simply give your P31 notice and the recipient can't tell whether it's valid or not.
Well, then they ask in the same way that they do.
But you say you don't have to tell them.
No. I'm sorry. I say you don't have to tell them in order for, before you serve your paragraph 31 notice, or at the point you serve your paragraph 31 notice, in order for the notice to be effective.
When do you have to tell them?
Well, as part of the ongoing dialogue. Otherwise, you will be penalised in costs when they issue their application to say, actually, we don't think they can make out the statutory grounds, or we don't think this is a valid notice.
But there's nothing by way of obligation that requires you to identify.
What,
Why 18 months is fine for a lease that has another 20 years to run?
My lord, just as there is no obligation on you to provide particulars to explain how your statutory grounds are made out. It's just, in reality, what happens in these cases is after you've served a notice, there's then a period of dialogue to explain why, whether this is or isn't effective. And the fact that you've also now got to have a dialogue about, well, why do you say you're entitled to serve this notice? Now, that's just one more part of that package. And the reason that it's that way is because there's nothing in the prescribed form that requires you to say, well, this is how I have calculated the date, or this is why I'm entitled to do it in this way. All that the prescribed form requires you to do is work out that date yourself and provide the guidance notes, which we looked at this morning, that explain to the recipient what the requirements are in relation to the date to be stated in the prescribed notice. And of course, what we do need to remember is that the exercise that the court is engaged in is not working out the best possible statutory scheme that might have been created had Parliament, in fact, had this particular lease or fact scenario presented to it. The exercise is simply to look at the wording that Parliament has used in the context and work out what it must have meant.
And test it by reference to potential practical examples.
Exactly.
Yeah. Well, my lords, I'm very conscious of the time. I've only got another 40 minutes or so before I need to hand over to my learned junior, and I've still got quite a lot of material to get through. Can I go back to the 54 Act as I was intending to? So far as I think the impression I have is that your lordships and your ladyships remain still to be convinced that the 54 Act is in fact the model for.
Well, we know it's a model, but we know it's not a copy out.
No.
So,
All right.
I think we've grasped that after all this time.
I'm very grateful.
I think my lady asked, what's the proposition you would like us to take from the 54 Act jurisprudence?
Well, I'm happy to come on to that. I just want to deal briefly with one point my learned friend made. He identified some differences between the Code and the Act, and presumably the purpose of that was to persuade your lordships and your ladyship that if you were against him in relation to what the 54 Act cases said, that they could then be ignored. But none of the policy arguments that my learned friend put forward would justify forming a different view between the Code and the Act. So my learned friend said, firstly, the Code deals with licences too. Well, yes, it does. He also said, well, the Code, you can have rights imposed, which I know is a point my Lord Holgate is interested in. That is true. The tribunal could impose an agreement, but the combined wisdom of my instructing solicitor and myself and my junior over lunchtime has yet to reveal a case where a tribunal has dealt with a disputed case in relation to a break right and done anything other than impose a redevelopment break in the same terms as the statutory grounds. So it's not, in fact, a practical problem that's arisen. And thirdly, my learned friend said, well, that these are low-value cases because of the no network assumption. And we say, well, if anything, that would suggest that it would not have been intended that what you had to do to terminate a code agreement was more complicated than what you had to do to terminate a 54 Act tenancy. So we say there isn't, in fact, a policy justification in this case which justifies treating the code differently from the Act. Your Lordships and your Ladyship would have seen the case of Stevenson in the bundle, and there was a departure. It was found that there was a policy reason underlying the code for why there should be why the OME principles, which basically say when you've got the existing terms, just sort of carry forward unless there's a reason not to do so on renewal under the 54 Act. And in Stevenson, what the tribunal said was, no, there is a reason in the code not to do that, because the policy of the code was to give operators something new. And so to give effect to that policy, we are going to do something different. My learned friend has not pointed to a policy reason here why the words could have, in the same provision that deals with the date that needs to be given in a statutory termination notice, should have different meaning. And we say that the meaning as it's interpreted in the 54 Act is very clear in the authorities. There are 4 Court of Appeal authorities, and in each one they say that you do not need to serve a contractual notice or comply with some other contractual requirement, like a service requirement, in addition to complying with the statutory scheme. The first one is Scholl. Scholl was a slightly confusing case because in that case what had happened was actually the statutory notice was given for the contractual break date. And so what the Court of Appeal said was, well, that's a secondary reason. And it's shown most clearly in Lord Diplock's speech at pages 75 to 77 in the authorities bundle. And he gives very short shrift to the second point, the second argument, i.e., well, none of this matters anyway because it was all given for the same date. He says, I don't think I'm wrong on the first one. We just don't need to go there. And Lord Justice Wynne agrees with him. Lord Justice Harman is not quite so clear, but he says in the subsequent case, actually, I think Lord Diplock explained it better than me. Lord Justice Diplock explained it better than me. So it's Lord Justice Diplock that one needs to look at in that case, and he, in my respectful submission, is extremely clear. As I say, there was that factual difficulty that, in fact, the notice was given for the right day. But that factual difficulty didn't arise in the next case, Commercial Properties and Wood. And Commercial Properties...
So the point you get from Lord Justice Diplock, can you just give that again, please?
That you do not need to serve a contractual notice in addition to a statutory notice, because the statutory scheme has replaced the contractual termination regime.
And that's at 50B.
I'm sorry, I'm using the pageant.
Yeah, I'm sorry, 76.
Bundles from there.
76 is 50B.
Yes, that B is the substitution, and then down to C and D explains why the contractual scheme is relevant, and they're saying effectively just because of the requirements of the statute. The statute means that you have to look back at the contractual scheme to determine your dates, but that's why it's relevant. Otherwise,
2 points about the case. I mean, obviously, it's not dealing with a conditional break clause.
No.
And the second point is it's easy to see that the election to rely upon the notice to quit or the break clause, simple break clause provision, is being exercised by the Section 25 notice.
Well, yes.
There's no other way you can explain the Section 25 notice.
No.
No.
I mean, there's no other way you can really explain a paragraph 31 notice either, other than that the site provider is electing that he wants to exercise his termination right. It's the same.
Well, it might beg the question, which one?
It might do in a conditional case, but
Yes. Well, that's what I'm asking about.
all right. Well,
Anyway.
shall I just take your lordships through what the authorities show first?
Yeah.
And your ladyship. So the next case was commercial properties and wood, and in that case, there was a problem with the dates. The statutory notice was given to expire on April the 11th, and it was a monthly periodic tenancy. So for a common law notice to quit, it would have to have expired on the last date of the month or the first date of the month. So the statutory notice expiring on the 11th could not have been a common law notice to quit, and there wasn't a separate one. And and in that case, the Court of Appeal held this is good enough. Again, clear that you did not, that the notice, the statutory notice, didn't have to be a contractual notice, because it couldn't have been.
And where do we find that?
At 23G, all the landlord has to do is serve the facts.
No, go on.
The facts. So 23G, all the landlord has to do is serve a notice in the prescribed form,
Yep.
stating his date, and there is the end. And then at 24, Lord Justice Harman says subsections 3 and 4 seem to clinch the matter. And the point he's making here is there wouldn't have been any need to put subsection 3 in if the contractual scheme operated as well. The only reason you need to worry about the date, the statutory scheme needs to state a date and refer back to the contractual scheme to make sure it doesn't happen too early, is because the contractual scheme isn't operating as well. The only reason that the statute includes reference back is because otherwise it would fall away. So that's the point that's made there. And then at the bottom of the page, there's the argument is taken about the date. So there's a further point taken which had to do with the fact that rent payable under this particular tenancy was payable in advance. And then it goes on to say that if you give a day other than the first day of the month, it disturbs without warranty the contractual obligation to pay and receive on that date. And therefore you must choose a date to make your 6 months notice coincide with the date when the rent would become payable. And the principle suggested being that no more disturbance of the contractual relations of the parties is to be assumed than is necessary to give validity to the statute. So exactly the point that my own friend is running. And Lord Justice Harman says, I can't take that as a serious point. So you can't take it as a serious point that no more disturbance of the contractual scheme is assumed than is necessary. And you don't need to, your notice doesn't need to expire on the right date as per the contractual scheme. So it's not giving contractual notice. And then at 25D, Lord Justice Russell, I see no reason for narrowing it, i.e. the statutory scheme, in any way by reference to what was the contractual method of determining a tenancy until the Act of 1954 stepped in and made it irrelevant. And then at the bottom of that page, he's dealing with the same point about subsection 3.
In that situation, you couldn't serve the Section 25 notice unless there was something like a break clause, because otherwise the term would carry on contractually.
Well, this was a periodic, so he could have...
Yes, but whether Section 69 and the rest of it, and that's why I said something like a break clause, unless there was a provision in the contract to enable the term to be broken at an earlier date, periodically or by a break clause, you wouldn't be able to serve a Section 25 notice.
No, and that's the point of 25.3. If 25.3
all of
wasn't
this is
there...
perfectly straightforward if you're dealing with a simple break provision.
Well,
because
yes,
you're making it clear you're exercising that provision by the service of the Section 25 notice.
Well, my lord, you're not exercising the provision.
Well, not in one sense,
shows.
in a very strict, narrow sense, but when the statute says not earlier than...
But that's the point. You're complying with the statutory regime because you have to comply with that statutory condition.
Yes, I appreciate that. I see what you're saying, but that's not a complete analysis, is it? Because not earlier than would not save that Section 25 notice unless there was a contractual provision to break the term.
No, No, I accept that
So you have
you've
to
got
take both of those points together.
Well, the statutory scheme imports some of the contractual regime.
Well.
You've got to comply with it so far as it's imported. What my learned friend says is, actually, you go much further and you don't look at only the bit that the statute expressly imported, but you import a bunch of other stuff.
What you end up with, you have to be able to import the ability to break the term. There, and it's on a very limited ground, namely as to time. Other break clauses are rather more demanding.
Well, my lord, there's nothing in either the 54 Act or the Code that says that there's any requirement for a Section 25 notice other than this requirement to hark back to show that you could have terminated. Now, I say that's doing more work than just timing. So I agree with your lordship about that. I think could have is doing more than that.
Yeah.
But what I say is that's all. You just look at whatever could have requires you to do, and that is all that's required by the statutory scheme. And these cases make it clear that you don't have to do anything beyond whatever the statutory scheme is when we've worked out what it says. You don't also have to do the contractual scheme. So that's commercial properties and wood. The fourth one is Blunden. That's in tab 9. This one is a little bit more, well, they're all interesting. The difference about this one is it's to do with service. So the question here was, you had a notice, and in fact there were multiple notices, but one of the things the Court of Appeal considered was whether if you had served just a Section 25 notice, and you'd served it in accordance with those statutory requirements, but you hadn't served it in accordance with a contractual requirement, so the Section 25 notice couldn't be a contractual notice, would that Section 25 notice alone be enough? And the Court of Appeal said, yes, it would. It didn't matter if it couldn't be a contractual notice because the contractual notice provisions hadn't been complied with. All you needed was a Section 25 notice, and we see that the passages are page 133, paragraph 22 to 24. It's the highlighted section. So Mr. Barclay was the counsel for the tenant, and he said it's his second preemptive strike, and it's his submission that it was not enough for Mr. Lewison, who was for the landlord, to succeed on Section 23, that's the statutory service provision, and that if he contended the statutory notice also operated as a valid contractual notice, he had to demonstrate it complied with the contractual service provisions as well. Mr. Lewison submitted that was not how Section 25 of the Act worked. And then he cites from Skoll the passages that we've just looked at. And then the conclusion at 24, in my view, that's clear binding authority against Mr. Barclay's second preemptive strike. He says that at the end of that paragraph, only the statutory notice was needed. As Lord Justice Diplock put it, the statutory notice was not in addition to, but in substitution for, any contractual notice. So it's not just about timing, because it's the fact that it's not served in accordance with the contractual regime as well, also not a problem. And the last of the foursome is...
So just to be catching up, was that a Section 25 notice which relied on redevelopment?
I think the problem
because it wouldn't have relied upon the clause that was in which founded the break notice, because that was all about damage or destruction of premises, rendering them uninhabitable.
Yes, that's right. I can't actually remember what the statutory ground was.
Because it would be an example, in other words, of a statutory notice relying upon a ground different from that which founded the ability to break.
Yes, my lord, it is redevelopment, demolition, reconstruction, or substantial works.
Yeah, thank you.
So it is, yes.
Top of the next page, isn't it? Yes, section 31F, top of page 130.
Mm-hmm. And then the last of these cases is Siemens.
So where you get to with this is you would have to demonstrate that the conditions for the break clause were satisfied, but you don't have to serve contractually in accordance with the terms
You don't
of
have
tenancy.
to give your contractual notice.
And then the remaining questions are whether you have to serve a contractual notice at all, or otherwise tell the other party why you're bringing the tenancy to an end.
Well, I think the authorities are clear you do not have to serve a contractual notice, because under the 54 Act the timing discrepancy doesn't exist. You have to be able to show that you could have served your break notice on the same day as you're giving your statutory notice. So in these cases where they're saying the statutory notice is good enough on its own, it's not because they think there's still time to serve a contractual one afterwards, it's because a contractual one's not needed at all. So it's very clear in my respectful submission how the 54 Act works, that you only need to serve your Section 25 notice. You don't need a contractual notice as well. And there's not a single case that says, oh, well, although you don't need a notice, actually you still need to tell them what contractual grounds you would have relied on or anything like that.
Well, of course, that point didn't arise in that case. That was the service.
No, but I'm simply saying there's just nothing in the 54 Act that says that's how it works, that despite the fact that you didn't need a contractual notice and they're recognising that the statutory scheme is replacing the contractual scheme, nonetheless, you somehow need to still state a contractual ground. There's no suggestion of that in any of these cases at all. So the last case I was going to show the court was Siemens. Now, this was a case where it was actually about the validity of a break notice, but the court was considering why the break clause was in the terms that it was. And in doing that, again, the Court of Appeal, and this time I think it's Lord Justice Lewison, so point he's familiar with, but he's explaining why in practice the break clause was drafted in the terms that it was by reference back to the 54 Act. And the answer is because of how the Skull case was understood. And that's at paragraph 14. And again, he says, the Skull case decided that where a lease contained a landlord's break clause, the landlord did not have to serve a contractual notice because the statutory methods of termination were in substitution for and not in addition to the contractual methods. It was thus sufficient if the landlord served a Section 25 notice that complied with the timing requirements in Section 25. And then there's the same quote from Skull that we've looked at. And then underneath that, in the middle of paragraph 15, the decision that a contractual notice need not be served, but that a statutory notice or request could be served instead of a contractual notice, led to a fear that the tenant would effectively be able to break and then seek a new tenancy. And that's what explained the background to the way the clause was formed in that case. So we say there's 4 Court of Appeal cases that make it clear what the law is under the 54 Act. My learned friend, as I understand it, doesn't accept that that's the law, but we say it's clear. My learned friend has referred to 3 first instance decisions. I'll make very brief comments on those. The first is Weinberg. That was before any of these Court of Appeal decisions, and it was not a case about whether a separate contractual notice was required. It was a case where a separate contractual notice had been served before a break notice, and the issue was how did it work in those circumstances. Sorry, the break notice had been served before the statutory notice. So that was on a different point. The second case is Keith Rogers, which my learned friend took the court to a summary in a book rather than to the case itself. But if I may simply say this about the facts, the issue was whether a Section 25 notice that was served by a head landlord on a subtenant was valid. Now, the head landlord could only serve that notice if he was the competent landlord under the statute, and if he could have brought the subtenancy to an end by the date stated in the Section 25 notice. So to show that, he had to show that he'd served an effective break notice on the person in the middle. So the question was whether he had actually served a break notice, not a Section 25 notice. What he'd actually done is he'd actually served a Section 25 notice on the middle person when he should have served a break notice. And so the issue was whether that Section 25 notice could be read as a break notice. So it's not at all the question about whether you actually need a break notice where you're trying to serve a Section 25 notice. It's not dealing with that at all. And then Aberdeen, tab 8 in the authorities bundle. Again, this is the one where my learned friend said, oh, well, this tells you how conditions are dealt with in the 54 Act. So let me explain that. In this case, it was common ground that on the true construction of the lease, in order to break, you needed to show at the date you served your contractual break notice that you had a desire to redevelop. So under the lease, you had to show it at that date, not at the date of expiry. And the question was, under the 54 Act, you have to show that you could have served your contractual notice on the same day as giving the Section 25 notice. That's subsection 25(3)(a). So under the 54 Act, you had to have been able to serve your contractual notice. And in this case, in order to be able to serve your contractual notice, you had to be able to show that you had the relevant desire. So it was a requirement of the statutory scheme, in this case, to show that you had the relevant desire at the date of serving the notice, but not because you had to also comply with the contractual scheme, but just because of what the statutory scheme said. And so that is why the court was finding whether the desire at the date of serving the notice was in fact present or not. But then the court goes on to deal with whether you actually need two notices. My learned friend took the court to some of the relevant passages. But
the condition of desiring to demolish or reconstruct was a term of the lease, not a
it was both. It was both. So in this particular lease, the break requirement, you had to prove your desire to redevelop on the date when you served your contractual break notice. Yeah. But of course, they also relied on the statutory ground, which would have to be shown when the notice expired. So because of the terms of the lease, they'd have to show it on both dates here.
Was the statutory requirement intention?
Intention to redevelop.
Yeah, but they're not the same thing.
Not necessarily the same thing.
Isn't that what Lord Grabiner said? And he was concerned in issue 1 with the contractual position.
Yes.
There was a desire.
Yes, he was. So, because he had to be satisfied that the contractual notice could have been given on that date.
Yes.
And so he had to satisfy himself in that because of the date on which the contractual condition needed to be satisfied fell before the date on which the statutory notice needed to be given. He had to satisfy himself that it existed. Yeah. But what he said at the bottom of the first column of 109, is whether he's considering whether the Section 25 notice is enough.
Sorry, this is letter.
It's 109. It's unfortunately under the black lining in the sidebar, but it's the bottom of the left-hand column.
Thank
109. So the commissioners rely on Skoll, which decided that one notice. Oh, sorry. Perhaps I should start further up. So he's considering. At the top of that paragraph, I turn now to Mr. Johnson's question 2, namely, did the commissioner serve a valid notice or notices to determine the lease? So he's considering what notices needed to be served. And he starts with the Act notice, and he said it was regular in form. And then lower down that paragraph, he says, stated paragraph F, says the termination date referred to was a permissible date, in the sense it was one of the dates given in the break clause as being a date when the lease could be determined. And then he says it's necessary for me to decide whether or not the break clause was effectively operated. He says the commissioners rely on Skoll, which decided that one notice given under Section 25, which was correctly served in accordance with the requirements of that section, can terminate both the contract and the tenancy. On behalf of Aberdeen, it was argued that whereas here there are separate requirements respectively in the break clause and in para F, the correct course for the landlord to have taken was to serve 2 separate notices. Because I don't accept Aberdeen's argument. First of all, the notice need not, in order to take effect as a Section 25 notice, also comply with the requirements of the break clause and give written notice of the landlord's desire to demolish or reconstruct. And then he cites the very passages in Skoll that we've looked at, and then he goes on, second, and in any event, the notice can and should be read in conjunction with the covering letter. So again, in my submission, it's clear that the first thing he's doing is accepting Skoll and saying, well, you only need your Section 25 notice, but if I'm wrong about that, then it doesn't matter anyway. And I said inconceivable that having been directed and cited those particular passages from Skoll, that Lord Grabbanner wouldn't have understood what they said. So we say, in fact, when one looks at the totality of the law and the 54 Act, it's clear. And as I say, we say that that is to be adopted. We think that's what Parliament would have intended in adopting that same language and in saying that it was modelling its termination regime on the 54 Act. My learned friend makes a point about practice. We say there's no evidence about practice. We say the fact that and we accept many of the textbooks were frankly unclear or misleading about these requirements as to time. Not all of them, but some of them certainly were. But we say the reason for that and the reason why people would err on the side of caution is why wouldn't you? If it's easy enough to give your notice on the right, why wouldn't you do it? So, and there may, of course, be other reasons why you'd want to show that you've satisfied the contractual conditions, namely not being sued for monetary compensation afterwards, which I'll come on to. So I'll very quickly just say a few more things about conditions. We've largely covered that matter this morning. I'll be as quick as I can on this. Of course, the test in relation to the statutory scheme is whether, if it doesn't say it expressly, then it's a question of whether it's proper to make an implication. We say it needs to be compellingly clear or necessary for words to be written into the statutory scheme that are not there. We say my learned friend simply doesn't get over that hurdle. In relation, so there are, as I mentioned this morning, there are a number of different things. There's firstly the stating the contractual grounds, and I think I said what I need to say about that earlier. That's to say, there's no authority under the 54 Act. Parliament was concerned. There's no evidence to suggest that Parliament was concerned about this being a problem that needed to be remedied, and there's nothing incoherent about things, because we can just simply ask for information if it's not stated in the notice. And anyway, because of the timings, making a requirement to state a contractual ground would probably be futile, because you'd probably just serve every notice you could anyway. So it really wouldn't give any information to the other side. You'd simply say, well, in 18 months I might want to dispose, and if I can't do that, then I'll knock it down, and if I can't do that, then I'll stop maintaining it, and if I can't do that, then I'll do something else. And so it would give no real information in any event. But the key point is, of course, this point about acceleration. It's the fact that it's not just, or my learned friend's case, it's not just about maintaining the existing contractual regime. It's actually supposing that Parliament was intending to give operators something that they never bargained for as a matter of contract, without even saying so in the statute, because it's requiring the site provider to state their contractual grounds early, because 18 months is a very long period. It's much longer than is normally required for any kind of contractual break. So it's requiring them to state their grounds early, and on my learned friend's case, to satisfy both things that needed to be satisfied in order for your contractual notice to be given, but also anything that needed to be satisfied when your contractual notice was going to expire. So my learned friend says, although there's nothing in the statutory scheme that says that, we have to assume that Parliament was also giving this extra huge benefit to operators, which is to accelerate the time at which site providers had to do all of these things. And my learned friend doesn't deal with the problem that arises if we suppose he's correct. If we suppose he's correct, that actually if your contractual terms said, and I don't think it's a normal thing to say, but if they said, well, we'll pay you £1 million when you give vacant possession, if my learned friend says, well, you've got to pay that anyway, even though you haven't given vacant possession, you've got to pay it before you can even give your 18 months notice. What happens if the site provider fails, if he doesn't make out his statutory grounds, or indeed if he knows he's not going to make out his statutory grounds and all he's trying to do is get new terms under paragraph 33? What happens to the £1 million? Does the site provider get it back? Or does the operator? I think what my learned friend says was, well, it's the cost of being able to do business. The site provider has to pay his £1 million as the cost of being able to have a try at a statutory termination or a getting new terms from the tribunal. And we say it just simply can't have been intended to work like that. And the notion that my learned friend gets over the hurdle of showing that Parliament cannot have intended anything other than that, I'm afraid I say that's an extremely bold submission on my learned friend's part. We then come on to that's in relation to giving the notice. It was then common ground, in fact, as I understood my learned friend, that assuming you've got a valid paragraph 31 notice, you don't have to do anything else in order for the termination to be effective than prove your statutory ground if put to that trouble by the operator.
Sorry, I'm not following. I thought what you were telling us this morning is that the could have provision depends on being able to show that the condition upon which it's exercisable is satisfied.
Yes.
And you went on then to develop the time at which that would be so. So,
yes.
Are you saying something different?
No, perhaps I've gone over that a bit quickly. So the first question is whether there's a paragraph 31.
Sorry?
The first question is whether there's a valid paragraph 31 notice. And in order to, you test that on the date the notice is given. And if there are contractual conditions...
Are we talking about the contents of a paragraph 31 notice?
No, I think you're talking about the period of time which is in a notice, because so far as the statutory grounds for giving the notice, I thought it was common ground, perhaps it isn't, that you test those at the date of the hearing before
the statutory grounds, yes.
So it's not... So, but you're saying, so far as validity in terms of the period of time that is given, whether it should be longer than 18 months or only 18 months, that has to be capable of being determined at the date that the notice is served. Is that what you were saying?
Yes, I'm saying you determine the validity of the paragraph 31 notice at the date it's served. And at that date, you ask yourself whether on the balance of probabilities, the contractual termination could have been exercised by the date stated in your paragraph 31 notice. So whether you could have terminated under your contractual regime by that date. I say that's what Parliament has, that's the inquiry Parliament has mandated by the use of that could have wording, which is carried.
How can you possibly know that if you're not told the reason?
Well, you ask.
That's later. That's not in the date that you received it.
Well, but that's, as I say, my lord, we're slightly going around circles, but that's the same as anything. Whenever you receive one of these statutory notices, you're going to have to ask questions. You're not going to know whether they're going to be able to make out the statutory ground. You're not going to know any of those things. You're just given one page that says this is what we're intending to do, and there will have to be engagement and dialogue after that in order for both sides, certainly for the operator, to form a view as to whether this is a good notice or not a good notice.
And so you say on receipt, you would then ask what contractual ground is intended to be made out.
Yeah, I mean, our discussion here is very much skewed to the fact that I expect that your lordship's is going to want to hear from me about the contractual scheme in this particular case. But what we're dealing with at this stage is just the construction of paragraph 31. And it is not the sort of scheme that we've got in this case with all these contractual grounds and all of it. It's not common. This is not how telecoms leases typically are. So the fact that this is a particularly complicated arrangement should not skew the construction of paragraph 31. It's a possible arrangement, but we don't accept that this is a standard telecoms lease, as I mentioned earlier, if one looks at what the tribunal has done, so far the only sort of contractual, the redevelopment condition has been a redevelopment one that mirrors the statutory language. So we're not talking about this kind of complicated regime in a typical case. And the fact that this case is here shouldn't affect the language. One needs to look at what actually Parliament intended in the run-of-the-mill sort of case. And we say it's very clear what Parliament intended. So the first point is, have you got a paragraph 31 notice? And in order to establish that, you will have to look at, if you've got a break, whether you could have exercised it or not. And in some cases, like this one, that might be quite a complicated inquiry. In other cases, it won't be. But once you've got a valid paragraph 31 notice, then, as night follows day, you will be successful in terminating if you can make out one of the statutory grounds. There's no room for anything else. My learned friend accepted this. So if you've got a valid notice...
Well, just one of the statutory grounds, or the one that you've identified in
Oh, well,
notice?
I think we'd probably accept the one you've identified in your notice is the one that you need to make out. I think we'd probably accept that because I think that's how the 54 Act works. So that's it. That's the statutory scheme. As my learned friend accepts, there's no room for bolting things into it at any other stage. So why, we say, should we suddenly assume that we're bolting other things into it when we're looking at the validity of the paragraph 31 notice? But what we say is that doesn't give rise to any harshness, because the parties, and indeed the tribunal, if it wants to, can bolt things onto that by doing it in the way I mentioned earlier, by saying, if I agree, or if you exercise your statutory right to terminate, then you will offer them an alternative site if you've got one. Nothing wrong with that. That separate obligation would still be enforceable, because it's not saying this is part of your termination. It's accepting that the statutory termination would have been effective, and it's saying contractually there can be a separate obligation that goes along in parallel with that, and that is the obligation, if framed that way, to offer the alternative site. Or indeed, I suppose, to pay £1 million. If I exercise my statutory right to terminate, I'll pay you £1 million. Not that that would ever be seen in one of these leases, but...
Is this if the statutory grounds are not made out, or if they are made out?
No, this is a contractual provision, and we assume the termination's been effective, but our contract says, look, if I exercise my statutory right to terminate, then I'll offer you alternative site, or indeed the hypothetical that my learned friend posits, I'll give you £1 million.
So that's all within 32.4, is it?
Well,
Court must order the code agreement comes to an end in accordance with the order, but within that, it has quite wide discretion as to what it chooses to order. Does it?
Well, that hasn't arisen for decision. I mean,
I find that slightly perplexing. I mean, it's mandatory.
Yes.
Or must order that the code agreement comes to an end.
Yes.
In accordance with the order. I can see that it might mean the order not in accordance with the notice, because we may be past the time at that stage, and it
rarely
may be that there maybe have to be some transitional arrangements as a matter of practicality. But I would be surprised if that meant come to an end in accordance with terms which may include any of the things in paragraph 34.
I'm sorry, could your lordship say that again?
Yes.
Because I'm not, what I'm positive...
What you're suggesting, I think, that if we get to a 32.4 situation,
yes,
in which the site provider has established one of its statutory grounds,
yes,
the court can still say, we'll order the code agreement to come to an end, but...
It must say that.
It must do.
Yes.
But I think you're saying it can impose the conditions to that?
No, my lord, I'm not saying that. What I'm saying is that separately from the termination, which is what the tribunal will be concerned with, there may be a separate contractual right to the £1 million or to the alternative site or whatever it is. Because what I'm positing here is you've got a contract that says, if I exercise my statutory termination right, then I will do X. And I'm saying
it
there's
says if I, in order to exercise my contractual termination right, I must do X.
Right. So that's the next step. So the first step is if the contract said what I have said, if I exercise my statutory term right, then X, there would be nothing wrong with that. That would remain enforceable. Right? None of this arises for today, but I'm simply engaging with the conditions question. So the next step is if you suppose that the tribunal wanted to impose an agreement that said, as well as these statutory termination grounds, in this particular case, because of the circumstances, I want the site provider to have to offer an alternative site. I want to add that into the statutory regime. The tribunal could do that, but it wouldn't do it by making
under what power? Not under section 32(4. I think we just established, didn't we?
Well, I was dealing with the imposition phase, which is what my Lord Holgate was asking about. So what I was supposing was that we had a dispute before the tribunal where the question was whether the site provider should be required to offer an alternative site if it terminated. And suppose the tribunal wanted to impose that requirement. It could do that, and that would be effective.
Sorry, it's my fault. How have we got in front of the tribunal? We've got in front of the tribunal through the paragraph 32 process or the paragraph 33 process?
No, I'm so sorry we haven't. What I'm positing here is that my Lord Justice Holgate has asked about what happens when agreements are imposed. So that's under Part 4. There's an ability to go to the tribunal under Part 4 to get your agreement in the first place. And if you got your agreement, if the tribunal said, well, I want to add something, I want to bolt something on to the statutory regime because I think there should be an additional requirement in the event of a termination, and I think you should have to offer an alternative site. And the tribunal could do that because it could say, it could impose as a term of the agreement, if you exercise your statutory termination right, then you must offer an alternative site. Now, that provision wouldn't stop your statutory termination being effective. You go through and do everything that we've talked about. You'd serve your notice, you'd state your statutory grounds, and you'd do everything else. But once you'd done all of that and it had been effective, you would have a separate contractual obligation to offer the alternative site, which could be enforced in the usual way. But that has got nothing to do with whether the termination is effective, because it's assuming that the termination is effective. And the reason I'm talking about this now is because it may well be that if there are cases like this, where the parties have misunderstood, on my case, how the statutory regime works, and they've added on these contractual conditions, the courts might interpret those as saying, instead of saying, I won't terminate unless X, as if I terminate, then I will do X. And in that way, the contractual regime could have a separate life, if you like, that doesn't stop
the simple point
the statutory...
There may be some provisions which don't impinge upon continuation.
Yes.
And termination.
Quite. And one might construe...
But on the other hand, if you've got a redevelopment clause with its paragraph C, Roman 2, whichever one it is, which asks the question, well, can you have a workaround, a bit like a Heath and Drown situation, that's actually qualifying, potentially cutting down the ability to terminate on the redevelopment ground, contractually.
Yes, or you could say that actually what that's saying is if I exercise my statutory termination right in circumstances where I haven't done X and Y, then you get some compensation. So that's my simple point about my learned friend's kind of disaster scenario that, you rip everything up and you start again. I don't think that's true.
Forgive me because I'm not familiar with Part 4 and we haven't got it all reproduced here, but can the operator commence Part 4 proceedings at any time?
Yes, absolutely. I could tomorrow walk into your garden and say I would like to put a mast in there. I mean, it's unlikely that would happen, but oh yes, I'm sorry. My learned friend, you would have to, of course, serve a notice before you went to tribunal and so forth. But yeah. Yes.
So the remedy is to do that alongside the paragraph 13 process.
Well, it's sort of one first and then the other. You would do the Part 4 process if you couldn't get your agreement consensually, and then Part 5 comes later in time once you've got your agreement by one method or the other and it's coming to an end. I'm very conscious of the time because I haven't actually started to cover the contractual scheme.
Well, I'm perplexed, but you keep going.
Can I just mention the authority of City of London and Fell, which is in tab 7 in the authorities bundle. This is again a 54 Act case, but I mention it now for this reason. This was a case where there'd been an assignment. The tenancy had been assigned, and the question was, when the tenancy was continued by virtue of the statute, did the original tenant's contractual liability also continue? And what the Court of Appeal, in fact, we've got the Court of Appeal here because that's where the reasoning is, but the House of Lords dismissed an appeal from it. What they said was the contractual requirement of the original tenant is a separate thing from the continuation / termination regime. So all that the statute tells us is that the tenancy continues, and it doesn't say anything about the contractual regime, and so the original tenant's contractual liability isn't extended. So I appreciate that's sort of the converse in a way of what I'm saying, but I use it to illustrate the point that just because there was a statutory regime that governs continuation and termination doesn't mean that you read that as getting rid of separate contractual monetary provisions.
You don't have a contractual right to them. If the entitlement to payment under the lease is a conditional one, if you terminate for this reason, you must pay me a break amount. If you're right in your argument and you don't have to, and you don't exercise that contractual option, there's never any entitlement to the money, is there? Where's the contractual entitlement to the money?
That's a very specific type of clause. So normally the clause would say, if here are your termination rights, and I will pay you X when you give vacant possession. It wouldn't normally be linked to terminating for that particular reason. So I'm anxious to move on to the contractual scheme, and then, as I say, give my learned junior her time also to deal with the reason decision, because that also we haven't even begun to cover. So I'll just finish very briefly on this scheme. We say the statutory termination scheme is clear, simple to comply with, as Parliament intended. It doesn't accelerate the date on which the site provider can terminate because of the requirements of paragraph 31(3)(b). You can determine whether the paragraph 31 notice is served, when it's valid, whether it's valid or not, as anticipated by the statutory scheme. And the statutory scheme itself was intended to be an adequate protection for the operators. There's no reason why they need additional notifications that they might have bargained for, like, for example, pink paper or additional grounds. And there's nothing absurd in anything I say, because it's not impossible that the contractual provisions might have a separate life. They've got nothing to do with termination or the validity of the paragraph 31 notices. Dealing then extremely quickly with the contractual scheme, we've already looked at the break provision itself. What the Upper Tribunal did was two things. It said there are two questions, and we say it identified the right questions. It started by identifying the reason why BT wanted to terminate. and it made a finding of fact about what that reason was, which is one reason, and it said it was because it wanted to be able to surrender its lease to the head landlord with vacant possession. That was the finding of fact the Upper Tribunal made. We say that was the correct finding of fact. As I say, my learned junior is going to say some words about that momentarily. But the second question that the Upper Tribunal dealt with is whether that reason, the reason that they found, falls within the general termination right, ground 5, on its true construction. I was going to say something about the dates, but I think it's common ground, having heard my learned friend, that under the contractual scheme, the date on which the conditions need to be established is the date of expiry of the contractual notice. My learned friend accepts that, certainly in relation to grounds 1 to 4. We say that must also be the same in relation to ground 5. It can't have been intended to create a curious patchwork where some of the grounds had to be established at the date of giving notice and some of them had to be established at the end. So the question is simply whether, when the notice expired, any of the reason fell within any of the grounds, and if it didn't, then it's ground 5. My learned friend did suggest that I think you've got to know what your reason is when you serve your notice. Well, in a sense you have, because of course you've got to put something in the notice, and you've got to give your notice bona fide. You can't put something in a notice that you know there's no possibility of you making out by the end of the...
This is your statutory notice now? Yes.
No, this is the contractual notice. My lord, I moved on to the contractual scheme. I'm very sorry.
Sorry, okay.
So, my learned friend's submissions were premised on the assumption that you have to elect a ground when you serve your contractual notice. Because he said, you must know what your reason is when you serve your contractual notice. And I said, well, I don't see why that's so. Why shouldn't you be able to serve more than one contractual notice? Why shouldn't you, given that you've got to serve it 12 to 13 or perhaps more months ahead of the date when you've got to establish those grounds, why shouldn't you be able to say, well, I would like to sell, but obviously I don't know when I'm going to find a buyer. And if I don't find a buyer, then in 12 months' time, if I've given it a good crack at marketing, then I'm going to cease to maintain the building at that point because it can't go on forever. Or I'm going to do some works I haven't quite decided yet. But anyway, what I know is I'm going to give it a year and try and market and see what happens.
I mean, there'd be no point in serving more than one contractual notice unless each notice specifies the ground which the landlord has in mind.
Well, but that's exactly what I mean. If the landlord's uncertain at that point, what's going to happen, what's going to be the position by the time they expire, then they could serve contractual notices for those different grounds.
There's only any point in doing that if you have to say what the notice is about.
The contractual, yes.
Otherwise, you could just serve one notice and say, well, it can be about any of the grounds.
The Upper Tribunal held that for the contractual notice, you did have, on the construction of the lease, you did have to state the ground.
And that's not challenged.
We're not appealing in relation to that. So we accept on the contractual notice that if we have to serve a contractual notice, which we don't accept, but if we're wrong about that, then we accept that we would have to state the contractual ground as a matter of construction of this lease.
So the effect of there being no statutory requirement to serve a contractual notice is that piece of information doesn't have to be given at that stage.
In order for the paragraph
of the
31.
Supplanting of the contractual position.
Yeah, although of course that information wouldn't have to be given at that stage, even under the contractual scheme, because the paragraph 31 notice is given early.
Oh, yeah.
So that's the point. Is one the choice that the court has is between saying, oh well, Parliament intended you to have to decide all this stuff very early and tell somebody, or actually Parliament just intended you to be able to do what you could always do.
Actually, we'll leave aside the timing point. The point remains, doesn't it, that if you're talking about serving more than one contractual notice, the only point of doing so is because you have to actually say why you're doing it contractually, otherwise you just have one notice. So the effect of saying there's no need for a contractual notice is what the operator loses is notice as to what the ground relied upon contractually is.
Well, yes, but of course, if he doesn't need, if the contractual, if all you need to show is you could have made out one or other of the.
But if it's contested, then there's going to have to be a resolution of whether one of the contractual grounds is made out.
Or, yes, would, on the balance of probabilities, you would have been able to make out one or the other. You might not need to prove any one in particular. You just might need to show that you would have been able.
You might prove more than one.
Yes,
but
yes.
You have to prove at least one.
Yes, but you might be able to simply say, look, it's obvious that I would have been able to satisfy either this one or that one by the end, and so it doesn't matter because you can assume that I might have served as many notices as I would need to have done. And of course, this comes back to the point I made earlier, that because you can serve multiple notices under the contract, why on earth wouldn't you? Why? How does it help the operator to get a batch of notices that sort of says, well, it might be this, it might be that, it might be the other? Why read that into paragraph 31? I don't want to sort of muddle the submissions. I would, if I may, just focus on the contractual scheme for a moment, because we
so
are
you accept that
fast
on the
running
contractual
out of time.
scheme you have to state the ground?
Yes,
Thank you.
as a matter of construction of this lease, not necessarily in every case.
I know.
And that is important. But
Well, the lease doesn't expressly require that, does it? The tribunal treated this as implied, didn't it?
The tribunal said it. That's what must have been intended. There are certain. I'm really anxious not to waste time going down a rabbit hole.
What you just said, though,
doesn't arise.
Okay.
And for what it's worth, the condition in subclause C, for example, we see wording like, provided that if the landlord shall exercise the rights in clause 5.88 on the basis of. So there is wording which justified the Upper Tribunal's conclusion. And we, as I say, we don't seek to argue with it because it's just a question of construction of this particular lease. But of course, that doesn't mean that wording would have applied in every other lease. So if, as a matter of construction of paragraph 31, the Upper Tribunal's finding is that you've got to state a contractual ground, the effect of that would be you'd have to state that contractual ground even if your lease didn't require you to do that, or even if there was only one contractual ground, or even if who knows what. So that's why I say it is quite important to keep the construction of paragraph 31 separate from this particular lease. So what the Upper Tribunal said about ground 5 is the reason, first of all, you ask, is the reason why the landlord wants to terminate something which is not within 1 to 4? And if it is, then the general termination right's open to you. So the question is whether the reason is within any of the other grounds. And the reason, assuming the reason decision stands, the only one that could possibly be relevant, if the reason is because we intend to surrender in the future, exercise our option to surrender, it can't, I mean, that's got nothing to do with 2, 3 and 4. So the only one that we could possibly be talking about is 1. And what the Upper Tribunal said about 1 is that is only available where a contractual commitment exists. So in effect,
I'm not sure they actually said that, but that's.
Well, they said it in argument, actually. Yes, yeah.
They don't explain at all why 1 doesn't apply, but it's conceded that it doesn't.
It's explained in the.
You have to have an actual disposal or agreement to dispose.
It's accepted that that's a finding that was open to the Upper Tribunal to make. We don't.
Well, they didn't make that finding.
Well, they didn't explain it in terms in the decision, but it is clear from passages in the exchanges with council during submission.
Well, those aren't findings of fact.
The finding of fact is made expressly. The finding of fact about what the reason was is made expressly.
Yes.
But now we're talking about the construction.
It is carrying out work with a view to surrender, and the carrying out of the work merely incidental to the surrender.
My learned junior, Miss Hemans, is going to deal with the reason decision. So rather than take up her time by me trying to deal with it for her, I think it's probably better if we leave questions about the reason for my learned junior. And I'm intending to deal with the construction of ground 5 and ground 1. So far as ground 1 is concerned, what they said was it only applies, it was clear from what they said in argument, it only applies where the contractual commitment existed. And so their view was that the reason that was covered by ground 1 is because a disposal has been effected. So the reason covered by ground 1 isn't because I propose to dispose or anything else. It's because a disposal has been effected.
Or agrees to.
Yes, well, disposal has the meaning that covers agreement. Yes, absolutely, absolutely. But that is slightly different, for example, from 2, because 2 is where alteration is proposed.
Can you remind me which page?
I'm so sorry, 341.
Thank you.
Bundle. Supplemental bundle.
Yep. Thank you.
And so the reason that's covered by 1 is if a disposal has been effected, or because a disposal, I want to terminate because a disposal has been effected, then you'd be in 1. If your reason is because I want to be able to exercise my option in the future, then you're not in 1. And so it's an other reason which puts you in 5. It's really as simple as that. That was the Upper Tribunal's construction, and we say there's no proper basis to interfere with that, because the Upper Tribunal considered the construction of ground 5 against the background, and specifically against 3 things. Firstly, before the lease was executed, there was a prior agreement in December 2020, which recorded various, the prior lease had in grounds 1 to 4, and then there was an agreement that said we're going to agree a new lease which applies to different type of sites, and we're going to add, quote, a no-fault termination provision.
Is this in the tribunal's reasoning?
Certainly I think they do refer
So
to...
it would be helpful to refer as to where they deal with it, perhaps.
Perhaps we go to... Well, I'm looking very quickly. I don't think I can see reference in the decision itself to the Type A lease, but it is. I
remember it being in the skeleton.
It is referred to in the skeleton below. That's at page 77 in the supplemental bundle. 77 to 78, and then again 82 to 83.
So 77, which paragraph?
Paragraph 22 sets out the original master site agreement, included middle of that paragraph, a form of lease agreement known as the Form A form lease, and then there's reference to where that appeared in the bundle, which applied to sites which hadn't been developed, and then other sites were under a management agreement. And then at paragraph 23 is reference to this December 2020 agreement I've just mentioned, which would transfer them onto a new form of lease. And then, again, it's perhaps helpful to look at it here. The enabling agreement was made just after open-reach consultation on exchange closure, and then the parties agreed to to agree a template B form lease, and they set out a sort of roadmap for that, which is the starting point was to be the A form lease, but paragraph 4 includes the principle that each 2020 managed site undeveloped shall have a no-fault termination right, exercisable BT on the same notice period as contained in the relevant existing licence agreement. And then the lease that we're concerned with is the template B lease, agreed pursuant to this enabling agreement. And 5 is the clause that was inserted to give effect to Schedule 5 paragraph 4, which doesn't appear in the Form A lease. And then going on to page 82 of my submissions below in relation to construction of the break clause, and explaining again, referring back to the context and the Type A lease and the open reach consultation and the agreement, and really taking in some detail through the Type A lease and what its provisions were. And that was all done during submission as well. And we've got the bits in the transcript if necessary. But so that's part of the background. There was this prior arrangement, and 5 was added at this stage in respect of these new sites and intended to be a no-fault termination right. The second part of the background is this telephone exchange closure programme, and there'd been a consultation by Openreach about it, and that is in the bundle. And the evidence was that On Tower knew about the telephone exchange closure.
Can you just give us some references? The point is that Openreach...
There'd been a consultation about a pilot, indeed a wide programme to close telephone exchanges. The building that we're concerned with here is a telephone exchange.
Yes.
And it was known before this lease was entered into that BT was intending to divest itself of a number of telephone exchanges. In fact, it was also...
Including this one?
Include that this one was to be one of the pilots, yeah. And it's accepted.
And a reference to support this?
Well, I can give you a reference in the transcript at page 137 to 138 of the trial bundle. That's where I asked their witness about whether they were aware, whether BT was aware of the exchange closure programme.
This is a supplemental bundle.
Supplemental bundle? Yeah. 137.
Page
137.
Thank you. In the middle of the page.
Well, it starts at B, the Openreach consultation. I'm sure, and then the judge says she's sure it would have been available to the parties. And then at the middle of the page, Mr. Barnes, do you have any reason to think BT's plans to close telephone exchanges was not something that was known to people within your firm? I think there was a general understanding. And then Malone Friend was asked if he was aware that they were going to say no. And then over the page, the date is established at E on page 138, that when Mr. Barnes, came into the role in 2021, the person who's dealing with the BT portfolio was aware that there was a desire to close exchanges. So it was part of the background that everyone knew there was going to be this exchange closure programme, and that's why this no-fault termination right was included. And then the contractual framework between BT and its head landlord. Again, we haven't got all the documents about that in the bundle, but the fact that that was part of... we have got some of the documents about that in the bundle. I don't know how much is in dispute about this, but there is a contractual right for BT to surrender up to its head landlord. As Malone Friend said, it's quite a complicated structure, but on 6 months' notice, provided that vacant possession can be given. And vacant possession is defined as requiring not only the termination of derivative interests, but also the removal of all telecoms equipment. So it's quite clear what needs to be done for us to satisfy that right. And it's also quite clear that that also was part of the background. It was a publicly available document, that lease. So we say that it's plain that the parties would have intended that if BT was trying to divest itself of a telephone exchange in accordance with its telephone exchange closure programme, that would have come within 5 if it didn't come within 1. That's part of, that is the background, the genesis of this particular provision. And what my learned friend's construction amounts to is that 5 can only apply if you're never going to, if whatever your reason is never going to enable you to make out one of the grounds. So I don't quite know in what circumstances my learned friend says 5 does apply, but even if he's right that there are some circumstances when it could apply on his construction, there's nothing in the language to limit it to such cases. Furthermore, the outcome is somewhat curious because what it means is that BT could terminate if they had any reason at all other than wanting to operate the option to surrender, which was the very background to the transaction. Any other reason at all, they'd be able to terminate. But if they wanted to terminate for that reason, then they couldn't operate the termination right. We say that's completely inconsistent with the contractual background and makes no common sense as to how that regime was supposed to work.
Well, as I understand the point, or at least as I see the point, it is your statutory notice has to be given in good faith. The statutory notice said the intention was to redevelop. If it was an intention to redevelop, then so far as the contractual right is concerned, it must have been works which would necessarily come within alteration.
Well,
what's the answer to that?
We don't deny that to make out the contractual ground you have to show that you intend to redevelop, and we don't.
The statutory ground.
Sorry, the statutory ground. And we don't deny that we intend to do work. But we say what we intend to do is a different question from what our reason is. And ground 5 is specifically directing you to look at the reason. And that's what the Upper Tribunal did. It accepted that on the true construction of ground 5, the first question is to identify the reason why you want to terminate. We say it made a finding of fact about that, and there's no proper basis to go behind that. As I say, my learned junior's going to deal with that in a moment. But having made that finding about what the reason was, it can't possibly be in alteration.
Where do you get reason out of the wording of 5.8?
5.8, subparagraph 5, the landlord wishes to terminate the lease, we're agreed about that, for any reason other than the reason set out in subclauses B1 to 4 inclusive. And as I understood my learned friend's submissions, he wasn't arguing with that. he accepted that the first question is, what's your reason for wanting to terminate? What is your reason? And then once you've identified what your reason is, you then look at whether it is the same reason as the other grounds or not.
So that's different from the statutory notice, which must identify grounds on which you propose to bring the agreement to an end.
Exactly. That's about intention again. It's about simply saying, I intend to redevelop. That's what you've got to show to make out a statutory ground.
Well, I was about to say,
not the reason
really is a ground. And what matters is the language used in 1 to 4. I mean, the reason is just a label to describe the circumstances, or whatever you want to call them, which fall within 1 to 4.
Well, my lord, that is not the position taken by my learned friend. He's in fact specifically not appealed. That was more or less what he argued below in the Upper Tribunal, and the Upper Tribunal rejected that, and my learned friend hasn't appealed on that basis.
Where the Tribunal dealt with this?
Yes, I think it's paragraph 93.
Thank you.
94. Perhaps
94, isn't it?
Well, 93 is the claimant's argument. So the claimant's argued that ground 5 was not available because the respondent intends to do that. That's alteration, they say. And then we said the stripping out is incidental to the real reason why it wants to end the lease in order to surrender the vacant possession. The fact that's what we want to do is not in dispute. That is not a reason within grounds 1 to 4. It's not arguable the only ground within 5.8 the respondent could have relied on was the one that matched, or at least was closest to the redevelopment ground. according to the respondent, could, absent paragraph 30 of the code, have brought the lease to an end by serving a break notice on the ground set out in clause B5 of the lease. We agree with that analysis. Ground 5 was available.
In the event, you could have more than one reason entitling you to exercise a break clause. So even if you have for the sake of argument, a reason which falls within Roman 2, if you've also got a reason which falls within Roman 1, you would say that's enough.
Well, I would say...
Oh, sorry, I beg your pardon. I meant to say, if you don't have one which falls within Roman 1, then simply because it's a surrender, and you could otherwise use 5 in order to cover a surrender situation, you're not prevented from doing that because, in addition, you also propose to carry out some works which fall within 2.
Well, but the question is what is your reason for wanting to terminate the lease? Is your reason for wanting to terminate the lease because you want to do the work, or is it because you intend to exercise your option?
And what is ground? How does that differ from ground in the statutory?
Well, if the statutory ground was the reason why you want to terminate the lease is because you want to do redevelopment work, then you would have to show that was your reason. But it doesn't say that. It just says you intend to. Just like the alteration ground here just says alteration is proposed. It doesn't say to get in the alteration ground statutorily or contractually, you don't have to prove that the reason you're trying to terminate the lease is because you want to do the work. You just have to prove you're going to do the work. So this is different because 5 is specifically directing you to look at the reason why you want to terminate.
I think what I was struggling to say was, let's forget, imagine a situation where no works are going to be carried out, but you've got some other statutory ground for serving a paragraph 31 notice. What you want to do is to surrender.
Yeah.
But that doesn't fall within Roman 1. You say that the fact that it's not a disposal doesn't prevent you from relying on Roman 5.
Yes, because the reason, if your reason...
And that analysis doesn't change if you move to a second scenario where you do additionally want to do some works, you've still got the reason under Roman 5, which is, I want to surrender.
If that's still your reason,
yeah,
yes.
Well,
yeah. If
but
that's
there were surrender arrangements in being, weren't there?
Well, what the Upper Tribunal...
In contemplation.
Exactly, it was an option to surrender rather than any contractual obligation to do so at that point.
Yeah.
And so that's why the tribunal said, well, that isn't... You'd be in 1 if your reason for terminating is because you've effected a disposal. But you're not in 1 because that's not your reason and you haven't effected disposal. So your reason for terminating is not 1. And because we found as a fact that your reason is because you want to exercise this option to surrender, it's not anything else either. So it's 5.
I mean, one of the oddities about 5, it doesn't even require any judgment to be reached as to how good the reason is.
No, that's not surprising because the parties had agreed, remember, that they were going to add a no-fault termination right.
You've explained the context.
Yeah. So it was intended to be something, a sweeper, a broad sort of catch-all for this type of lease. And so the notion that all of a sudden somehow we construe 5, that we're not within it, if we want to exercise our option to surrender.
All 5 excludes is no reason at all. Sorry.
Well, I think 5 probably excludes, I mean, if we had actually effected a disposal, then we'd have to, and that was the reason why we wanted to terminate, then we'd be in 1. Yeah.
We've been through that.
But 5 only applies if none of 1 to 4 apply, correct?
Well, if the reason why you want to dispose is not within 1 to 4.
But isn't that loose language for 1 to 4, surely?
Well, we say not, and as I say, that's what the Upper Tribunal found, and the way in which my learned friend has premised his appeal is on the basis that the reason decision is wrong, and therefore ground that preliminary issue needs to be decided differently. So there's not been a suggestion, aside from a curious sort of exchange of correspondence that we had on Friday and Tuesday this week, there hasn't been a suggestion that actually that underlying decision about what ground 5 means and the correct approach is to identify the reason and then see if your reason is within 1 to 4. That has not been appealed. And I say it's not right at this stage to shift the goalposts because we haven't got the open reach consultation, we haven't got the type A lease, we haven't been through all of the background that was available to the Upper Tribunal when they decided what ground 5 meant. They've made a decision of construction that this is how ground 5 operates. You ask yourself these 2 questions in this order, and we say that's should be respected. The language is clear. There's no other reason to depart from it. It says reason. There must be a reason for it saying reason.
Unless my lords have further questions, I think we need to move on.
Yeah.
So where are we? I think you've.
I think I need to finish, and I'm going to hand over to my learned junior to deal with the reason decision.
Thank you. Ms. Hemmons.
I will address you on the reason decision as my learned leader has indicated. And this crosses over first round 2 of the appeal, the procedural irregularity and the alleged injustice of it. And also it overlaps with ground 3, which my learned leader has covered in respect of the construction point, but I'll address you on ground 3 in relation to whether or not the reason decision itself was wrong. So dealing firstly with the procedural irregularity, we accept that there was a procedural irregularity in that the Upper Tribunal took into account Mr. Seller's evidence when coming to their conclusions when it should not have done so. We accept that. But what we do not accept is that that procedural error was serious and caused an injustice in circumstances where the exact same decision would have been made in any event. And we say this based on the party statements of case, the admissible evidence, aside from Mr. Seller's evidence, and also the way in which the parties put their cases below. And so I intend, in the time available, to take your lordships and your ladyship through BT's case below and also On Tower's case below to see precisely what was before the Upper Tribunal and what would have allowed them to make this decision aside from Mr. Seller's evidence being taken into account. So dealing firstly with BT's statements of case, because of time I'll give you the references but I won't take you there, but on page 21 of the supplemental bundle it's paragraph 12CI and paragraph 12D. And in both of those paragraphs, the case is made clear that...
Sorry, CI and
12CI and 12D.
Are these references in a skeleton somewhere?
Yes, I'll come on to the skeleton.
That would help too. Yeah.
No. I think you're saying you're going to come on to the skeleton below.
Yes.
But are they're not in the skeleton for this hearing, are they?
There are references in the skeleton for this hearing, but they're not the entirety of the references we intend to rely on for these purposes. But
So 12D.
I don't want to detain you. Do carry on.
I'm grateful. And so those are the references from BT's statements of case, and that makes it clear that the reason is because BT wants to effect a surrender to its landlord. That is the reason why On Tower's lease is being brought to an end. And that is a point that's picked up again in the skeleton below, and I'll give you the reference again. That's supplemental bundle page 75, and also supplemental bundle page 85. At 75, and it's paragraphs 15 and 16, great detail is given as to the contractual provisions between BT and its landlord, setting out the fact that it's necessary to obtain vacant possession, but also to clear the site entirely of all of the electronic communications apparatus, including that belonging to their tenants. And then at 47 on that page, again, it's made clear that the evidence will be that BT's reason for terminating On Tower's lease is because it wants to hand back vacant possession to its own landlord. And then I come on to BT's evidence below. The relevant documents my learned leader has already referred to in terms of the head lease agreement. Those documents were before the Upper Tribunal and submissions were made in relation to them. And the reference is supplemental bundle, page 127. There are then two...
Sorry, can I just see what that is? That's 127 supplemental bundle.
Yes, you'll see there at B, top in the middle of the page, opening submissions by Ms. Tozer, and then at G on that page, you'll see it says just to show the tribunal some of the contractual framework, and then it goes on for, I believe, two pages where my learned leader takes the tribunal through the contractual framework.
This is building on what's just been summarised in the previous document you showed us, in the skeleton.
Indeed.
It's basically the same point, is it?
Well, in the skeleton argument, the points are set out there, but in terms of dealing with the underlying documents,
That's what I'm just, yes.
that the tribunal were alive to the point.
So this is giving the supporting detail to back up the skeleton.
Indeed,
yeah.
Yes. And for your lordship and your ladyship's purposes, we have the extracts in the bundle, and the reference is page 264. That's the extracts from the head lease.
Mm-hmm.
And then we also have extracts from the Telereal MPA, which is at 256.
Well, 264 is the cover sheet for the head lease. 256 is the cover sheet to the master property agreement.
Yes, and so they're extracts from the relevant agreements, and as has already been indicated, how they interrelate is rather complicated, but I commend those sections to your lordships, as explained in the skeleton argument below.
The skeleton will give the references.
Indeed.
Thank you very much. The skeleton before this call.
No, the skeleton argument before.
So we've got to search through that.
I think for the purposes of this court understanding precisely how they interact, reference could be had to the transcript where my learned leader takes the tribunal through precisely how they interact, and that's supplemental bundle page 127.
Yes, indeed, to 129. Thank you.
Exactly.
Thank you very much.
So I now come on to two critical documents, we say. The first one is the business case summary document, and that is supplemental bundle page 362. And I would invite your lordships and your ladyship to turn to that particular document. So this is a document which is dated the 28th of June 2022, so before the notice was served. And the author of the document is Mr. Prance, who gave evidence before the Upper Tribunal. We can see his name in the fourth box on the left-hand side under the heading Rapid Case Information. So it's Mr. Prance writing this internal document, which effectively is making recommendations to the business as to what needs to happen for the exchange closure programme. And you can see in the box that says Executive Summary that as part of the Simple Network programme, 5 pilot locations have been identified for closure. 3 of those locations have mobile operator equipment and require a notice to quit to be served. And then it explains that the 5 pilot locations are at the base of the document, and 2 pages over on page 364, there is, in the unredacted part of that document, reference to the Kenton Telephone Exchange. So this site was one of the sites in view when this document was prepared. And then going back to page 362, in the background section, there's reference to the paper put forward to Ofcom that identifies the need for closure, and then it goes on to state, for these vacated buildings to be returned to the landlord in the main Telereal, a certain number of conditions need to be met for handback, the key one being the removal of all telecommunications equipment, including the cessation of any mobile operators at the location. And there are 2 further points in this document that are worthy of note. Over the page, there is, in the second row, decision required. agreement on the serving of 3 notices to quit. So this is Mr. Prance saying that the decision he needs the business to make.
So this is page.
This is page 363.
Yeah.
Second box.
Second box.
Thank you very much. Got it.
So the decision required is that notices to quit are served. And then we have 2 boxes below that. Other options considered. Do nothing. So do nothing is an option that is considered. And it's stated there, as the removal of mobile operators is a key requirement of a successful handback, BT would be unable to complete a handback of the 3 properties. And so it's clearly stating that it's not possible to effect the closure unless these notices to quit are served and the operators are removed. And we say this is a document that clearly explains the reason why the notices are required. It's because in order to effect the handback to Telereal, one must terminate those mobile network operators on site.
What's meant under the decision required, serve the 3 notices to quit and remove the undeveloped notice? What does that mean?
I'm afraid we don't have an answer to that question. But one thing which might assist is the fact that during cross-examination of Mr. Prance, he was taken to this document and he was asked a series of questions about it. And at no point was he challenged that the basis of the decision that was being made was not because they wanted to affect the exchange closure programme. It simply wasn't suggested to him. I can take you to that reference if it would assist.
Might possibly have something to do with the second bullet point saying notifying operators that 2 locations that are undeveloped will not be available for development. Might have some significance.
Perhaps.
Perhaps.
I cannot say.
No.
But if I could take you to page 152, the supplemental bundle. This is the transcript and the section of the transcript where my learned friend is asking questions of Mr. Prance. And before I go on to this document that we've just looked at being put to him, you'll see at A, there's a question asked of him about conversations with Miss Ali. And at B, just above C, you'll see there was a question, you presumably told her about BT's right to surrender or giving back to Telereal, something of that nature, is that correct? And the response comes, I'm trying to think of a date when we had those discussions, but I actually can't remember the date and the time of the discussion. And so it's not being said that he doesn't remember the reason, it's being said that he doesn't remember the conversations, and that's something that my learned friend sought to suggest during submissions.
So that was page
152.
152. Sorry, I was just making another note.
At
Thank you.
BC.
Yeah.
And if you look at the bottom of that page at F, you can see the question is put, there are just a few documents I want to look at briefly in bundle 3, page 205. And then my learned friend takes Mr. Prance to that business case summary document. And the first set of questions is about the authorship, and we can see over the page at 153, where the question is put, so you're the one making the recommendation, and the answer is yes. And then there's a series of questions about those who had input into the decision, but crucially, at D on that page, there's a question about the background section, which we've just looked at. Now, in the background section, you note that there are a certain number of conditions that have to be met by handback, key one being the removal of all telecommunications equipment, including the cessation of any mobile network operators at the location. It goes on, and Mr. Prance confirms that that is correct. At no point is it suggested to him that the reason why BT want to terminate on Tower's lease is anything other than the fact that they want vacant possession so that they can effect the exchange closure programme. It's just not suggested to him. And so the suggestion by my learned friend that had he had the opportunity, he would have put relevant questions as to the reason and was not able to do so, it is simply not a good one. He had the opportunity to question Mr. Prance and did not avail himself of that opportunity. I would also invite the tribunal to look at Miss Ali's evidence, and this is at 162 of the same bundle, just very briefly, at B, in the middle of the section between B and C, Miss Ali is asked about the alteration ground. So moving to the other ground, the alteration ground. Are you aware of that ground? She says yes. And then at C, there is a question, why did you dismiss that one? So she's been specifically asked about the alteration ground. Her response is, I dismissed that on the basis that our purpose was to obtain vacant possession on the premises. And when I chose the sweeper clause, because it essentially, as I said in my witness statement, encapsulates all eventualities. And so that was a perfect opportunity, we say, from a learned friend to put it to Miss Ali, that the real reason was because there was a need to do a programme of works. And that's simply not how the case was run. It wasn't suggested to the witness at any point.
Well, the real and only reason.
Precisely, yes, my lord. And we say that it was perfectly possible for On Tower to run that case below, and it did not do so. And I don't believe my learned friend can point to any passage in the skeleton below, or in the transcript, or in the submissions, or in the evidence under cross-examination, where this point was put to a witness or suggested in closing submissions. In fact, when one looks at the statements of case, supplemental bundle page 10, paragraph 16.
Assembly case, supplemental SB
10.
10.
Paragraph 16.
Thank you.
The way the statement of case was put on behalf of On Tower is this. It says,
I'm so sorry, what page?
10.
page 10. Where it stated, nevertheless, the claimant understands that the respondent has no intention to carry out the proposed development works, whatever they may be, but instead to transfer or surrender its interest to a third party. And so, in our submission, this seems to suggest that actually they accept that this is what BT intends to do. It's not until we get to their statement of case in response, and I'll give you the reference, it's supplemental bundle 31 at paragraph 15.3, where they seem to be putting BT to proof on this assertion in BT's statement of case that this is the intention. So at best we say the point is confused. It's not clear whether this is an issue or not, except for the fact that when we get to the trial, no questions are put to the witness, and neither is it suggested in closing submissions that there is some other reason at play. And so, to summarise, we say that even if the Upper Tribunal had not taken Mr. Sellers' evidence into account, the conclusions reached by the Upper Tribunal would have been the same in any event. The conclusions were inescapable. The Upper Tribunal would have made the exact same decision given how the case was run below. And as such, we accept that there's a procedural error, but we say it's caused no injustice in the circumstances. And on that basis, we say ground 2 must be dismissed. However, if you are not with us on that point, then one must consider what order needs to be made. And my learned friend invites the court to remit the matter back to the Upper Tribunal for further consideration. And we say to do that would cause a great injustice to BT. It would give On Tower an opportunity to rerun their case, and there should be no question of that. And also it would be highly prejudicial to BT, given that the longer this matter goes on for, BT are prevented from terminating their lease, and therefore they're still liable to, under the contracts with the terms of the contract with their landlord, and so they're still liable to pay rent, etc. Those obligations are ongoing. And so we say it would be to put BT to expense for no good reason if the matter were to be remitted.
I'm sorry to slow you down, but I was just looking at the passage in Mr. Prance's evidence after the one you showed us at 162, when, sorry, not Mr. Prance's, Miss Ali's evidence, when she was asked, 162 in the middle. First of all, he said our purpose was to obtain vacant possession. She explains that actually she thought 5 included 1, 2, 3, 4 as well, so she thought it didn't matter. whether it was 1 to 4, because 5 covered everything, even if it was within 1 to 4. And then lower down the page, she's asked about the paragraph 31 notice. You stipulated 2 grounds, one of which was C. Do you remember? Yes. Why did you cite redevelopment clause if you didn't think the alteration ground was appropriate? And she says, because that was the closest ground I could choose in order to obtain a concession. The sense is in order to be able to give notice to close the site. Why did you pick that ground? Going back to the top of the page, I picked a ground based on the fact that we needed vacant possession, and I chose a ground that was closest to achieving that goal. Checked it with various other people in my team. That was a recommendation that I made. Now, if the question that the tribunal, the Upper Tribunal, had posed to it, i.e. is the P31 notice valid, did it not have to address the question as to whether that was given in good faith? And if it did, what evidence was there from anyone other than her that redevelopment was a ground that existed?
Well, I think that there are 2 things, my lord. Mrs. Alley, her evidence on that particular section was directed towards the statutory grounds and whether or not there was a relevant statutory ground that could be put in the paragraph 31 notice. What I'm addressing you on is the question of the reason for the purposes of the general termination provision within the contract.
I understand that. But the point that I say that I think is put against you is if the P31 notice was given in good faith, then the ground for the statutory termination must have been an intention to redevelop. And if that was given in good faith, then how could it not also have been alteration within subparagraph 2?
Well, in our submission, there is no inconsistency with saying that the reason to terminate was because it wanted to effect a surrender to its own landlord, but also saying, and yes, we intend to do some works, and that would be sufficient for the statutory purposes. That is not...
Under the lease, you had 2 grounds, potentially. One, on my lord's question, 1 and 2. It so happens that when you came to the Power 31 notice, you had to put forward a statutory ground, and that was the redevelopment ground. But if otherwise, you also genuinely had, in terms of the break clause, a paragraph 1, sorry, I meant to say paragraph 5, I keep doing this, paragraph 5 situation, then that doesn't change just because you also have an additional contractual ground, namely ground 2.
Yes.
Except that
the trouble with that is that 5 only arises if you don't have any of 1, 2, 3 or 4. And if you have 2, you can't have 5.
I think this line of questioning is trespassing on grounds.
And I understand you've already addressed the point of there being a difference between reasons in 5 and intention in the others and grounds for the statutory notice.
Yeah, I mean, I think, to be fair to Melanie Junior, her submission is directed to the finding of fact about what the reason was. So should we let her finish with those? And if there are questions in relation to the construction, I think
let's let her finish because we are running very much behind time.
Yes. There are 2 further references that I should have provided, and for your note, Mr. Prance's written evidence. This is at page 59 of the supplemental bundle, paragraph 78 and 79, and then also...
Sorry, supplementary bundle 59?
Yes.
And it was paragraph
78 and 79.
Thank you.
And then also over the page, paragraph 80, where he details the reasons, but then also his second witness statement, supplemental bundle 62, and page 65, paragraph 17.2 in particular, where he deals with the wish to terminate on Tower's lease the reasons why. So I commend those passages to your lordship and my ladyship. So just to conclude then on round 2 of the appeal, we say that even if you're not with us, the matter should not be remitted, but it should be a decision remade by this court without the need to refer it down to the Upper Tribunal, and that we say would be more in line with the overriding objective. And we say, given the evidence and the way the matter was presented below, undoubtedly there is no other conclusion possible as to the reason why BT wished to terminate on Tower's lease. It remains for me to address you very, very briefly on round 3. We say that the reasoned decision was not wrong, as it was never suggested by BT that it could terminate, that it wanted to terminate because it wanted to make alterations. That wasn't suggested to any of the witnesses, and that wasn't a submission that was made in closing arguments either. And we say that there is a distinction to be made between the statutory ground and the actual reason for terminating. And Miss Ali's unchallenged evidence was that she had dismissed the alteration ground because BT's purpose was to obtain vacant possession. And as for the argument that the reason was to make a disposal, well, my learned leader has already addressed the position on that. And so we say that everything that was done was directed towards the same reason, which was to be able to hand back to Telereal. And it's for that reason that vacant possession was necessary, given the contractual scheme in the background. And so we say the Upper Tribunal reached a very rational conclusion based on the evidence, and there's no basis to go behind their finding of fact on that point. Unless I can assist the court further.
No, thank you very much indeed. Mr. Lees?
My lord, you'll be pleased to hear very few points in reply. I'll endeavour to be extremely quick in the circumstances. Can I just deal with one point of clarification from something my learned friend, Ms. Heem, has just said? In terms of what was or wasn't below, in terms of the alteration ground and the points put, 3 references I just would give my lady and my lords. The first is indeed supplemental bundle page 162, which my lord took Ms. Heem's to in respect to the cross-examination of Miss Ali, where the consideration of the alteration ground, the interaction of the paragraph 31 points were certainly put live. And 2 references, I've only got 2 references for now because I've had a few minutes to find them, but there are 2 references just to show that the tribunal certainly understood the point that was being put. If we could go to page 217 in the supplemental bundle, right at the top of A, I've just been asked by Judge Cook over the page of 216, if they're saying it's disposal and they're wrong about that, what's wrong with it remaining paragraph 5? And I said at that point, well, in those circumstances, firstly, because they could have relied and should have relied
217,
on... A, forgive me, my lord,
A.
right at the top.
Right.
They could have relied on and should have relied on alteration, given their paragraph 31 and their stated intentions. So that was put in my closing. And then at page 250, C, in discussing, my learned friend was given the opportunity to reply. 250, 250, and C. My learned friend was given an opportunity to reply, including on this point specifically. And Judge Cook neatly summarises at C, I think Mr. Lees's point, as your client stated in their paragraph 31 notice, that they wanted to redevelop. And therefore it's rather difficult to say that they do not wish to do so. And then my learned friend, Ms. Tozer, responds to that. I, of course, will leave ladyship and your lordships to look at that as well. But just to make clear, I don't accept at all that it wasn't suggested below that the fact that this paragraph 31 had cited such an intention didn't give rise to the fact that they ought to have been seeking to rely. Whether they could make out the ground or not is a separate question, but in terms of their reason, that it was ground 2 under the contractual scheme. Having dealt with that, I've got 5 extremely short points, and I will keep myself to 5 and I'll move through them at pace. In response to my learned friend, these all concern now the ground 1 point, in dealing with the submissions of my learned friend, Ms. Tozer. Firstly, she said that it would be, to use her word, futile to serve a contractual notice, or to require a contractual notice to be served when dealing with a Part 5 termination, because it would create parallel regimes, essentially. That's not right, and that's why I've used deliberately the phrase an anterior gateway. The point, whether I'm talking contractual, as my Lord indicated earlier in the context of other contractual situations, such as repudiatory breach or forfeiture, the point is that you have to take the first stage in order to get you into Part 5. It's not to try and create some parallel regimes. And it's also not futile. In this case, it wouldn't be futile for a start, because it would tell you whether you, what the contractual grounds were they were relying on, so you could stress test those. But secondly, because it would tell you what obligations and preconditions would apply and would fall to be satisfied. So it's not futile. Secondly, my second point, and my learned friend talking about the purpose of paragraph 31, and she described it as being simply for the benefit or a right for site providers. In my submission, that's not right for two reasons. Firstly, I accept the point it's a balance. It's a right for site providers to serve the notice, but the inherent limitations built within are for two sets of benefits. Firstly, of course, the operator, because the operator has the benefit of operating on site, but also the public benefits, my Lord Justice Holgate indicated in discussions with my learned friend. And that's a particular justification or reason, for example, of having the 18-month period, is to maintain network coverage during that time. And so taking the forfeiture example, which was dwelt on with my learned friend, it may well be that having forfeited the contract, you then serve your notice and you have to wait 18 months, but that's not for the benefit of the operator as a huge boon. I mean, it may be practically that, but it is, what's the purpose behind it? It's to maintain network coverage, and it's for the benefit of the public benefit. Thirdly, my learned friend, I think I can take this point very shortly, because I think my lords and my lady dealt with this with my learned friend, but just to cover it off, my learned friend posited a situation where, well, we could always sue them for the, let's say, the £100,000 contribution afterwards. But as my lord said, there's 2 points to make in response to that. The first is that my learned friend actually posited something that wasn't a condition of a break. She posited an obligation to pay the break having been exercised. That's a completely different question. What we're concerned with here is where there are preconditions to the exercise of the break, and the break by the break date. And if you have to pay £100,000 in order that you can break, that is a separate thing from saying that an independent obligation to pay arises upon the break. It's to put the cart before the horse. It's to reverse them. And in my submission, for the reasons I discussed earlier, there's no justification for that at all. Secondly, even if that were to work on a financial issue, such as you can see for £100,000, whatever it is, when we look at the non-financial examples, and I'll take the example of the alteration ground in this case, the benefit of the conditions imposed there is the opportunity to say, no, actually, I've got a workaround. You don't need me off for a full 12 months, or I've got a workaround so you can work around reasonably without me. And the loss of that opportunity, the benefit of that, is about staying on site. It's about having the opportunity to continue the agreement, to make it so that it's no longer necessary to be ended. And it would be wholly inadequate, and there's no suggestion that somehow a potential damages claim, which I'm not entirely sure I follow, but even if it exists, that's not a suitable response in my submission. My fourth point deals with paragraph 33. To underline this point, that the effect of my learned friend's submissions today is that a landlord-only break is in fact a misnomer. It in fact becomes a mutual break, because the minute the landlord has a break, the operator can exercise it. So that's my hijack argument, put with different phraseology, I appreciate. But it occurred to me while she was speaking that that's actually the effect. It required, the effect of P33, given my learned friend's interpretation, is that a landlord's break would never exist. It would automatically be a mutual break, because the operator could always rely on it for the purposes of serving a P33 notice to seek to renegotiate the terms, or to require different rights mid-term, or indeed to require a different financial payment mid-term, all of which are capable under that process. The fifth and final point, by way of response, is what I think is a potential correction. If we could go to the decision, which is contained in the core bundle at page 89. It may be I misunderstood the point, and if I did, I apologise. I don't want to set hairs running. But I thought I understood my learned friend to say that the Upper Tribunal had determined that your paragraph 31 notice had to specify your contractual ground, or you had to provide that information as part of it. At paragraphs 84 to 86, they deal precisely with this point on page 89. And what they say at 86 is that they agree with my submission that as a matter of practicality, the tenant has to be given the information in order for it to assess whether paragraph 31 was valid. And over the page, the site provider may choose to provide this information in the form of an actual break notice, as it did here, or it might simply tell the tenant the ground on which it could, absent paragraph 30, have brought it to an end. That doesn't mean the actual break notice has to be served. I certainly didn't read that as requiring that someone write it into the paragraph 31. And maybe my learned friend wasn't suggesting, but I had understood she was saying that. And if that's right, then I don't think that is what the decision was. And that's why I said yesterday in my submissions that there's a tension between what the tribunal says about the contractual notice and all of the correct and good reasons as to why we would need to know the contractual break reasoning then. And yet when we get to the paragraph 31 reasoning, they say, well, actually, you don't need to know any of that for a valid notice. You can find all that out later at a certain time. And that's why I made that point. I just make that good. And they're my 5 points. And so my final comment, one comment is this. My Lord Justice Popplewell rightly identified there were 3 different levels or layers you can compare our positions on. The first is the legal right. That's not really an issue here. You simply look at the question, is there a break clause in the lease or in the licence? The second are the facts in the factual circumstances and whether they give rise to that. And then the third is whether you actually have to exercise. I absolutely accept and adopt, if I may respectfully, that analysis. In terms of the third, though, just to be clear, the real distinction from my learned friend is twofold. Firstly, it is about serving the notice. In some instances, it might be a double duty single notice, but in many instances, it may not be. In this instance, it couldn't be because it needed to provide the contractual information. But it's also about then the satisfaction of the conditions. And that, in my submission, leads us back finally to the point of absurdity where my learned friend, as she confirmed, you have to show that you have the money, but you don't have to pay it. You have to show you have the site, but you don't have to offer it. You have to show in the alteration ground case you would have been able to have a conversation about whether there was a workaround, but there wouldn't have been a workaround. All of those things you have to do in this fantastical hypothetical way, but not in the actual way. And in my submissions, for the reasons I outlined yesterday, that's not correct. My lady, unless I can be any further assistance, those are my submissions in reply.
There is one thing. Could I ask for your help on page 340 to 341 of the supplementary bundle? And I'm afraid it's our old friend 5.8.
My lord, I knew precisely, as soon as you said the page number, I knew exactly
yes,
what.
well, I'm sure it's in grades. But Roman 5, the landlord wishes to terminate the lease for any reason other than the reason set out in 1 to 4. Now, part of the thinking that's been discussed during the hearing is that this can't be a way of circumventing any of the restrictions, for example, applicable to Roman 2, which you find in subparagraph C.
My lord, yes.
So if you've got a pure alterations case, no other potential ground within 1 to 4,
My lord, yes.
then you can't rely on 5.
My lord, no.
But you could have a situation where you have 2 potential grounds. Well, you could have a situation where you have a reason for terminating, which would fall within Roman 5, shall we say, if you didn't have any alterations to carry out.
Yes.
Like, for example, I want to surrender. I can't rely on Roman 1, I can rely on Roman 5. I mean, there's no dispute, is there, that if you want to surrender, you could rely on Roman 5, couldn't you?
Well, my lord, there is a dispute insofar as if you want to surrender, I say that means you have to try and bring yourself within 1 for the disposal ground, because if you either will agree a surrender or you'll have effected a surrender, what you can't do is say, I've got a desire to do what would fall within Roman 1 eventually, but I'm not actually going to do that, or I'm not going to do it yet, so I'm going to circumvent those restrictions by exercising 5. So I accept that if you were to have 2 entirely separate reasons for the same design, the same outcome, it must be conceivable that that's the case, in which case you elect between the 2. But where one falls within...
I thought you had accepted that Roman 1 only applies where you have disposed
Yes.
or have
Or
agreed
you
to
enter into
dispose
agreements.
at
Yes.
the date
That's
of the contractual notice.
well, yes, that's how you would, I accept that's how you'd make out the ground. I absolutely accept that.
Right.
But if you intend to do that, if that's what you're intending to do, you can't, by serving your notice earlier, obviate all of the protections that are provided in C1, is my submission.
What stops you?
Well, because in my submission...
You're not within one, and it is another reason.
My submission, the reason you want to do that then is, in fact, to get yourself within one. You're just at a too early a stage. It goes back to the point I addressed my lady on earlier in respect of my skeleton down below, about in response to my learned friend's amendment of her pleading, that we said if you want to rely on a particular, or if you intend to rely on a particular ground, but you can't make it out or can't yet make it out, then that isn't something that you can rely on to say, well, actually, that gets me within 5.
That was in your reply.
My lord, yes.
Thank you.
And so if your long-term intention is 1, even though you can't satisfy 1 at the moment, you can't be in 5.
My lord, yes. My lady, yes, forgive me, yes. That's exactly that has always been our point, and that is our point.
Okay.
My lady, precisely. And so on the question, to finish answering my lord's point, when one is dealing with the question of your reason, I can use that word, it's become rather loaded now as a term, but one is, as I said, one could say almost any, the reason I'm actually doing this is, yes, I want to do works, for example, but that's because I really want to make money. That's my motive. That's my reason for doing it. That's not stipulated within ground 2. What you actually have to focus back on in my submission is why is it that you're terminating this agreement? Why do you need to terminate this agreement? And in my submission, what you look at in this case, both because of what was said was to happen, but also in particular because of the paragraph 31 notice, is the intention is to carry out works. That's why there are works for which you will need to terminate the agreement. And so that's why their intention is ground 2. And that's also why I should just be clear, my lord and my ladies, before finishing, as I really tried earlier and yesterday to be very careful when I said, that's why I've always said about what your intention is in terms of, for example, the alteration ground. Whether you in fact can make out the alteration ground just the same as whether you can in fact make out the P31 ground is a separate question you'd have to look at. But the intention would be that. So if I can give a final example, in order to make out the alteration ground, as you will have seen, the works need to be such that you need to be out for 12 months. The interruption has to be to that extent. If in fact I want to do works that are, on any view, only going to take 3 months, in my submission you can't rely on ground 5. You can't say, well, actually, I can actually terminate this much more easily, because the works you're planning to do, what you're trying to do is alter. It's just the protections built in for the alterations are contained in ground 2. So exactly the same as I say ground 1. If you intend to alter, if you can't make it out, then that's a separate question, a distinct point from whether you in fact have a different reason, which is exactly the point we put in our reply and exactly the point I put in the skeleton. I don't think that probably adds very much to what I said yesterday. I just thought I certainly don't want to push. Having promised I would finish again, I hope on time, unless I can be of any further assistance, those are my submissions.
Yeah, thank you.
Thank you very much indeed, and thank you for being succinct. Thank you, in fact, to everybody for all your hard work in this very interesting and difficult case. You won't be surprised to hear that we will reserve our judgments, and we will circulate the drafts when they're available in the usual way. We must emphasise the embargo in relation to those drafts, and therefore please don't circulate them to additional people without having first requested permission. You will have already, I think, have submitted lists of emails of people to whom they ought to go. You will also know very well that we circulate those drafts so that you can assist us by correcting typographical errors and juvenile grammar, but not our reasoning, and you will understand that, I'm sure. At the same time, usually at the same time, as we ask for those helpful corrections, and we also ask for an agreed draft order in relation to consequential matters. And if you can't agree that order, then please produce very short written submissions, and I mean short, so that we can consider those on paper and make the decision on paper in relation to that consequential order. I don't think there's anything else I want to say to you, other than to thank you all again. Thank you.
Court rise.